Civil Judge Junior Division and Law Examinations, Law of Evidence in English language. Section 11 Indian Evidence Act 1872 or its corresponding section 9 of the Bharatiya Saksha Adhiniyam 2023 to be effective from 1st July 2024 is the topic for discussion today. In section 11, there are two clauses. Clause 1 deals with 6 topics, while clause 2 deals with 2 topics. So, in almost all textbooks, clause 1 deals with 5 topics, whereas in one article, 6th topic, 6th topic also non-execution of document was not covered in books. That also I am going to cover in this lecture, dear friends. In this lecture, we will discuss about section 11 Indian Evidence Act or section 9 Bharatiya Saksha Adhiniyam. So far as the contents of both the sections are concerned, the contents remain unchanged. No changes have been brought about under the new enactment to be effective from 1st July. Here, what are these 6 topics in clause 1 and what are these 6 topics in clause 2? We have to discuss. This section 11 Indian Evidence Act or section 9 Bharatiya Saksha Adhiniyam says that when facts not otherwise relevant but relevant, when facts not otherwise relevant become relevant, this means there are certain facts, they are not at all relevant, but they become relevant because of some peculiar circumstances. So there are 2 clauses enshrined in this particular section stating that there are 6 cases under clause 6 with reference to inconsistency, and there are 2 concepts in clause 2 relating to high probability and improbability. What are these 6 plus 2, 8 topics we have to discuss. Here, when in any claim, when trial is going on in a court of law, if it is civil litigation, some claim is made either by plaintiff or defendant or petitioner or respondent. Similarly, in a criminal proceeding, some charge is leveled against a particular person, or a person is alleged to have committed an offence, or a person is charged with an offence. What is the position of complaint, FIR, investigation, inquiry, trial? All these aspects I explained in detail in criminal procedure code, dear friends. Now, when when there is a fact in issue in a civil proceeding, or a charge, that is charge allegation as to crime is an issue in a criminal case, the affected person will try to disprove whatever allegation is made in this particular civil litigation, or whatever allegation is made in this particular criminal proceeding is not correct. Here the other party tries to invoke section 11, either clause 1, one of the 6 items, or clause 2, one of the 2 items, stating that that allegation is no way connected to me. I hold no responsibility, and he will try to get exemption. In simple words, section 11 clause 1 provides 6 situations wherein the defendant can disprove and escape liability, or in civil case. In criminal case, the accused can invoke any one of the place, either accused or the defendant can establish any one of the facts and escape from the liability. Here in criminal law, IPC, criminal law 1 IPC, there is chapter 4 containing, providing for various defenses or general defenses. In that chapter, there are so many defenses available to the person who has committed the offense. The person who is guilty of, even after having been proved that particular person is guilty of particular offense, murder or any crime, he can plead the defense of right of private defense, insanity under section 84, accident under 80, and various grounds are there. The accused can get exemption from the criminal liability. Here, a person on whom an allegation is made says that no, I am no way answerable or accountable for that. So the allegation made through the testimony, either by oral evidence or through the documentary evidence, is inconsistent with the fact in issue or relevant fact. Inconsistent. There is no connection between that allegation and my act. That is, so you are telling that I committed that murder in particular Calcutta. No, I am not in Calcutta on that day. I was in Bombay. That is. So that is, you are telling that that pregnancy for the child, for that child, I am father. You are telling no, I am no way answerable to that. That child is not a legitimate child. That is illegitimate child because I was away from my wife for more than 1 year. These things. Then another thing is A is charged with offense of B, but after some time B comes back, as in movies. Then the allegation is inconsistent regarding. So offense committed at one place, the accused is available at another place. That is inconsistency. So the pregnancy is there, the husband is not there. That is inconsistency. Husband can challenge that I am not the legitimate that child is not the legitimate child of my own. I am not the father. He can claim. Similarly, A is charged with offense of killing B, murdering B. After some time, B comes back, as in some movies, as is in Talson case. Then then similarly, the person who A is charged with offense of killing B, but B returns after some time. So like this, A is allowed to have committed murder of B, but subsequently it is noticed that B, it is not murder, it is suicide. Like that, so many instances are there. Under clause 1 provides for, if whenever a witness appears in the court and presents evidence, if that evidence is consistent with the fact in issue or relevant fact, that statement can be admitted, that statement can be accepted and can be received, and the party invoking any one of these pleas can avoid liability. So these 6 points under section 11 clause 1 or section 9 clause 1 are nothing but pleas, protectional defenses, in just like defenses, though not defenses. With the help of these, a person against whom any allegation is made will try to avoid. If he is able to prove that there is inconsistency, it is disproved, he can avoid liability. If the inconsistency is not established, he will be answerable and accountable, and he will be punished, or his claim will be dismissed. So these are the 6 points. In second, probability or unprobable. What is the probable? A highly probable means most likely to happen, most likely to be true. That man is a very very brilliant man. He is likely to get selected in a district judge exam. That is likely. There is a small little ray of doubt that he may not be selected. That is highly probable. Improbable, that man doesn't know anything ABCD. How he will be able to get selected? There is no chance. That improbability means not likely to be selected. So in this particular case, section 11, the heading of section 11 Indian Evidence Act, or section heading of section 9 is when facts not otherwise relevant become relevant under two circumstances. What are the, according to section 1? Facts not otherwise relevant become relevant when they themselves not relevant but become relevant if the consistency with fact in issue and relevant fact, they become relevant and provable in evidence. This is I want to, for your information, but I don't like to spend time for reading out the section. For now I read out and will explain everything. Section 11 or section 9, section 11 Indian Evidence Act, or section 9 Bharatiya Sakshya Adhiniyam reads as follows. When facts not otherwise relevant become relevant, clause 1, if they are inconsistent with any fact in issue or relevant fact. If any fact in issue or relevant fact. You say that I committed murder in near Howrah Bridge, Calcutta, but I was not there. I was in Madras at that time, or I was in Delhi at that time. I was undergoing treatment, or I was enjoying cricket match, like that. So the same person cannot be made available at two places. He says that in so many movies, the villain's son commits rape or murder. To protect the villain's son, the villain invokes the plea of ALIBI. Sometimes he will be successful, but with the efforts of hero, the plea of ALIBI invoked by a villain's son may not be admitted. So that is what is called facts not otherwise relevant become relevant if they are inconsistent with any fact in issue or relevant fact. What is fact? What is relevant fact? What is in fact in issue? These three topics are very very important. In every lecture I explained in detail, dear friend. You please read these three topics, by heart these topics very carefully, so that these three fact, relevant fact and fact in issue will appear in each and every section up to 55, from 5 to 55 in Indian Evidence Act, section 3 to 50 in Bharatiya Sakshya Adhiniyam. So facts otherwise relevant become relevant. Some facts are not relevant. They cannot be allowed in evidence. They cannot be admitted in evidence. But they can be admitted in evidence, but if they are inconsistent with fact in issue or relevant fact. What is inconsistency? A fact is said to be inconsistent. There is no coexistence with another. One fact is consistency means there is a coexistence with one fact and other fact. That is called consistency. If there is no existence with one fact is not existent with another fact, it is called inconsistent. So the government officers must function according to the guidelines given by the government. So if the government officers function as per the guidelines given by the government, that is consistency they are maintaining, the government officers. Government authorities give one guideline, but this officers function in another way, it is called inconsistency. But owner tells the driver, don't overtake, don't allow passengers, but the driver overtakes, applies excessive speed, entertains passengers. That is inconsistency. Like that, when an allegation is made that A committed murder of B, so the allegation is whether A committed murder of B. That is the point we find out. That is what is called relevant fact. Whether A is a criminal or not, whether he committed several crimes previously, they are not relevant. Whether A committed B or not B, and B killed A, allegation is there. That is the relevant. That is this relevant fact. The fact is from this relevant fact, issue is created. What is that issue? Whether A has committed murder or not. That is the issue. So likewise, if any inconsistency is established with reference to fact in issue or relevant fact, that is provable, that evidence is allowed, that plea can be allowed. Any one of these 6 pleas can be allowed. Next, clause 2. The facts, there are some circumstances, the fact itself or the fact itself themselves, either by facts itself or by facts themselves, or in association with another, fact or another fact or relevant, another facts exist or make the existence or not existence of relevant facts or fact in issue highly probable or improbable. Section 1, if there is any inconsistency in evidence testimony produced, that is oral evidence or test documentary evidence, if there is any inconsistency with the fact in issue or relevant fact, that can be disprovable. It can be disprovable. But second thing is, there are certain fact or facts, either by fact itself or by facts themselves, or in association with some other facts, may create either existence or non-existence. Either existence means the allegation is okay, right? Non-existence, the allegation is not correct. The existence or not existence make the fact in issue or relevant facts highly probable or improbable, most likely to take place, and there is no chance to take place. This is what second thing. So here, for first point, inconsistency means, number 1, A is charged with murder of B, but A says that no, at the time of murder at Calcutta, near Howrah Bridge, I was not there on that particular day. I was in Delhi undergoing treatment in hospital. That is elsewhere, another place. That is ALIBI. Or no, A made a defamatory false statement label, then B filed a case against A. If A can establish that, how can I write a defamatory statement? I am an illiterate. So B is telling that A has written a very defamatory statements. But if A is illiterate, he cannot. That is, A can invoke that I am an illiterate, I cannot do this. So this is the position. Now, that is illustration there are two illustrations given to this. For class 1, one illustration. For class 2, another illustration is given. A has committed a crime. A has committed a crime. That is the allegation or fact in issue. Whether A has committed crime or not, that is the fact in issue. The fact in issue. So it is said that the crime is committed by A or B or C or D. So every information, every testimony placed before the court with reference to the crime might have been committed by A or by B or by C or by D. That is the presumption, alternative things. Suppose Mr. A is available by this time at home, in office. If not office, college. He is available at this time in office. If not office, he is expected to be available at home. If not at home, he is available at the club. If not at club, he will be available at the ground for walking, like that. Like this, the offence is committed either by A or by B or by C or by D. That is the position. It is proved that B, C, D, it is proved that A is not at all claimed that claimed. A proves that I was no way present in that. I am no way. I have not yet done it. It might have been committed by B or C or D. That particular information will be that evidence will be adduced to disprove the allegation on A. So if it is said that B or C or D committed, A is not at all committed, it is highly probable that A has not committed that crime. That is one thing. So it is proved that A or B or C or D, none of them have committed. None of them have committed. Then none of them have committed. So then it is highly probable for fact in issue or relevant fact, A has not committed the crime. None has come means he has not at all committed. So if it is proved that B or C or D not committed, it is improbable. So if A challenges that I have not committed, but B, C, D not there, but it is improbable. He might have committed. Like that, the evidence cannot be entertained. So highly probable means it is likely to true, likely to happen. But the improbable means it is opposite. It doesn't happen. It does not happen. Either it may be the position will be reversed depending upon the proof from this side or that side. So either I give positive evidence or opposite may give negative evidence, both are same. If either I give negative evidence or opposite party gives positive evidence, the highly probable and improbable may change from situation to the situation. Now we have to discuss about now section 11 section 9 or section 11 Indian Evidence Act or 9 lays down various provisions relating to proof of the relevancy of facts. Class 1 covers 6 cases, class 2 covers 2 cases. What are the 6 cases covered under class 2? So I read out once again. Facts not otherwise relevant become relevant. Facts themselves not relevant but become relevant because of their consistency with fact in issue or relevant facts. Similarly, class 2, because of their connection with other facts, make the existence or non-existence of any fact in issue or relevant fact highly probable. Dear friend, if you read the contents of any textbook, any subject, it will be little bit confusing and difficult unless you have very good command over the language. You find difficulty, but we read all these things very carefully and explain all these things. That is the reason why I don't like to read out the contents of sections because it will take some time, but directly I am giving the meaning of this. So under section 11 clause 1, or Section 9, Clause 1 of Bharatiya Adhiniyam. There are 6 situations, 6 instances. Number 1 is ALIBI. Number 1 is ALIBI. Number 1 is ALIBI. Number 2 is access to. Number 1 is ALIBI. Number 2 is non-access of husband to show illegitimacy of child. And third one is survival of the alleged deceased, commission of crime by third party, self infliction of the harm alleged to have been committed, and non-execution of document. Under section 11 clause 1, we speak about the 6 situations. Number 1 is ALIBI. Details I will tell you. So the A says that A committed murder of B in Calcutta, but A claims that invokes the plea of ALIBI. No, on that day I was not in Calcutta, I was in Bombay or Delhi, like this. That is. Second, non-access of husband. Husband denies the child. No, that child is not mine because I am away from my wife for more than 1 year. According to Evidence Act, non-access of husband for 280 years, 280 days, that is 9 months 10 days. That if pregnancy takes place, if the woman conceives a child, that pregnancy is deemed, the child is deemed to be illegitimate child. Details I will explain. Commission of crime by the survival of commission. Suppose A said that A is charged with murder of B, but after some time A is charged, proceedings are going on. At the end of the proceedings, B turns out. So in one certain movies, either hero or hero related person is being tried for murder of somebody. That person is not killed, murdered. He returns before the court. Then the charge is lifted. That is the third one. So the person whom we presume that is dead, is not dead, but it is alive and turns, then the consistency, it becomes return of presumed dead person returns, it is inconsistency. So without husband's access, pregnancy is inconsistency. Third one is A is charged with murder of B. But if A proves that I have not killed B, but some D has killed or C has killed, then the A can get exempted from liability. In so many movies, we see that somebody from villain commits murder, that blame is thrown on somebody related, either hero or somebody. The hero is charged with murder, a murder case, and is undergoing imprisonment. In the last minute, real witnesses, real evidence is produced, and is proved that the hero is innocent. He is not the guilty of murder. Somebody from villain is a real culprit of committing this murder. That is there. So another one is self-infliction of harm. So sometimes in a family, daughter-in-law commits suicide due to some personal problem, but there is a doubt that that suicide, the relevant evidence act also is there. I will tell in course of time. What is that? So this woman, married woman, committed suicide means as a consequence of harassment, mental agony created by the mental cruelty inflicted by husband and in-laws, and immediately husband and mother-in-law, father-in-law or some others will be arrested. So these the family members, husband and his collaterals are arrested against the charge of murder of the daughter-in-law, but in course of time it is proved that it is not murder, it is only suicide committed by that girl. It is proved. So the allegation of murder is inconsistent with suicide, then these persons will be, they can invoke the plea of suicide and can get exempted from the liability. So in all these 5 topics are given in almost all the textbooks. But one more item, non-execution of document This appears in one article in internet. I also have added this non-execution of the document. What is this? So A purchased some land from B. A purchased land from B. Some transactions might have committed. Some amount might be given or full amount given or whatever it may be. The relation is between A purchased, B want to sell the land is true, A want to purchase is true, but whatever transaction took place, but B has not given possession of the land. But then A filed a case against the B. But I purchased B's land, but he has not given me the possession of the land. A filed a case against B. Then B said, how can I give possession, sir? The sale deed is not executed. When once sale deed is not executed, how can I give land? But the allegation of A that he did not give land is inconsistent with the non-registration of the sale deed. So that the seller can invoke the plea that non-execution of document. These are the for 6 inconsistencies. Suppose whatever it may be, when we purchase the immovable property, even though purchaser gives all the money, if the seller does not register the property, that property will be of no value in future. The purchaser cannot sell that property in future. So that is another important thing. Now coming to these are the 6 points. Among these 6 points, ALIBI is most important. In class 2, there are probable and highly probable and improbable facts we will discuss in detail. Now coming to the first point in detail. Now I have given an idea in brief. Now we have to discuss in detail. Now in section 6, clause 1, with reference to inconsistency of fact in issue and relevant fact, the first point for discussion is ALIBI. ALIBI means in so many movies, the plea of ALIBI is invoked to get exemption from the criminal liability. In so many movies, we see that villain's son is a mischievous fellow. He will commit rape of some innocent girl, and then he is charged with rape, and villain makes all efforts that my son is not guilty of committing the rape. He was elsewhere. He was at different place. When if it is said that the offense of rape was committed in some place A, but he was in different city, long away, long distant place. Maybe in Delhi, Calcutta, Bombay, somewhere undergoing treatment like that, he will produce the document. So that is what is called ALIBI. ALIBI is a Latin word. ALIBI is a Latin word which means elsewhere. Elsewhere means somewhere other than this. Elsewhere means some far away place. That is ALIBI. So here, by invoking the plea of ALIBI, the accused says that I was not present at the place of offense. When the accused wants to establish the plea of ALIBI, he must establish beyond reasonable doubts. He must be with accuracy. So whenever ALIBI is there, suppose when he has the burden of proof is shouldered on the person who invokes the plea of ALIBI. Suppose the general rule is the person who approaches the court has burden of proof under section 101 Indian Evidence Act, 104 Bharatiya Saksha Adhiniyam. Suppose if the plaintiff files a case against, if the creditor files a case against debtor, he took 1 lakh and did not give me. So the creditor has to prove that, he gave him 1 lakh. He received or he gave him 1 lakh, or the defendant received 1 lakh. He has burden of proof. Suppose if A committed rape or murder, the prosecution has the burden to prove as per Section 1 Indian Evidence Act, Section 104 Bharatiya Saksha Adhiniyam. In new act, the number of changes will change already. So here, whereas in ALIBI, so here Mr. X has committed murder or rape of some person. See, suppose X committed murder of Y or X committed rape of Y. Who has the burden to prove? The prosecution has the burden to prove. Here, according to the Criminal Amendment Act, Section 113A, 114A, so 113A speaks about suppose a girl, a newly wedded girl commits suicide. The presumption is that the in-laws must have actuated her to commit suicide. That is there. The burden of proof generally lies on prosecution, but the burden of proof is shifted from prosecution to the defense under Criminal Amendment Act. Similarly, in rape case, when the offence of rape is charged with somebody, generally the prosecution should prove, but that the burden of proof, the prosecution has to prove that so and so committed rape, but that the burden of proving prosecution is shifted to defense after the Criminal Amendment Act Section 114A. But so far this ALIBI, so far as when a person wants to invoke the plea of ALIBI to get exemption for liability, the burden of proof is shouldered on him under Section 103 of Indian Evidence Act or Section 106 of Bharatiya Saksha Adhiniyam. So here, suppose if anybody wants to invoke the plea of ALIBI, he should prove beyond reasonable doubts by providing testimony, by establishing testimony. Testimony may be by human agency, that is direct witnesses or indirect witnesses, or by documentary evidence. He can prove, no, I am not here, I was undergoing treatment, this is my medical bill, all this, like that he should sue. So the witness, the person who gives testimony either must be very genuine, very unsuspected, it must be genuine. The ALIBI witness must be impartial. Witness must be impartial and unsuspected, unsected, and unbiased. What is the principles of bias? I explained in detail in principle of natural justice in administrative law. Bias means, suppose I am judge, I should not try the case of my near or dear, my family friend or my son, my daughter or anybody. That is called personal bias. Suppose if I should not, as a judge, I should not try the case where for a company where I am having share in that company, shares or some partnership, some investment. So I should, that is pecuniary bias. Suppose I am a collector of the, suppose I am a judge or collector to give some decision, but any cooperative bank, I should not take case of that particular cooperative bank, because also there also I am the ex officio member. Like that, personal bias, peculiar bias, these things are there. So when a person wants to, when the person alleged to have committed an offence and the person who is charged with an offence wishes to get exemption from the liability, if he can invoke the plea of ALIBI under Section 11 of the Indian Evidence Act or under Section 9 of the Bharatiya Saksha Adhiniyam. When once he wants to prove it, he must prove it with absolute accuracy, without any doubt, unbiased, impartial and everything. But however, there are certain circumstances in which the accused may not be able to establish unbiased, disinterested witnesses. Suppose at the time of offense at particular place, he was sleeping at home, or he was at home, but no stranger, nobody is there, only wife and children, family members are there. But naturally, even though the family members give evidence that he was at home only, out of favoritism, they may say some doubt will come. It will be taken into consideration. Their testimony will be taken into consideration depending upon the circumstances of the case. But the unbiased, disinterested, accurate testimony, the person who invokes alibi may not be able to establish if he were at home at the time of offense. That is the another thing. So here in alibi, I already told you, for generally the burden of proof is who a person who files a case, who charges an offense, who makes a charge of who makes charge, he has a burden of proof. But alibi, generally, according to section 101 Indian Evidence Act, section 104 Bharatiya Sakshi Adhiniyam, the person who files a case has burden of proof. A person who files charge sheet, that is prosecution, has burden to proof. There are some exceptions: rape case, suicide case, abatement of suicide case. But so far as burden of proof in alibi case, the person who wants to invoke plea of alibi to get exemption liability, he alone has burden to prove beyond all reasonable doubt under section 103 of Indian Evidence Act or under section 106 of Bharatiya Sakshi Adhiniyam. So these are the issues. Now here there are some cases. What happened is Buboni Shahu versus the king. Buboni Shahu versus the king. In olden days, during British time, king was the ruler. Today we have state. Sometimes either emperor or king was one side, and the accused was one side. In that the Privy Council, before establishment of Supreme Court, Privy Council was functioning to hear the appeals of Indian High Courts and those Indian High Courts. But the High Courts were established, abolishing Supreme Court. All these things I told long back. So here what happened? In this case, it was proved that the plea of alibi should be established through the testimony disinterested or impartial witnesses. If the alibi witness is impartial and disinterested, it will have more evidential value. That is the decision. So here this topic also is over. Now there are other cases. Binay Kumar and others versus State of Bihar. In this case, it was said that when once the person invokes the plea of alibi, it must be with absolute certainty. Certain means definite. Absolute means no. There is no any little ray of doubt. Absolute owner means owner of the property is absolute owner. He can enjoy it, he can sell it, he can let it, or he can lease it, he can destroy it. That type of ownership is called absolute ownership. Unlimited ownership, he can hire or fire. That is certainty means there is no doubt, little ray of doubt, it will happen 100%. That is called certainty. In this particular case, the Supreme Court said in 1997 that when once the person invokes the plea of alibi, it must be established with absolute certainty. That is the decision. In another case, Brijlal Prasad Sinha versus State of Bihar. Brijlal Prasad. In this case, some police officers were charged with murder day of encounter. Whether encounter is genuine, okay. If the encounter is any malicious or defective, they will be charged with murder. So they say that we did encounter to prevent criminality, but it is proved that the encounter is false. They murdered the deceased. So here one police officer tells that I was not there on that day, I was not there on the duty, but I was transferred to some other place, one the accused said. But accused pleaded the plea, alibi. I was not there. But one eyewitness said that no, no, no. Though he was transferred, he was. I saw him in the place of encounter. The witness was accepted, and the plea of alibi was not entertained. Not entertained. So there is no inconsistency is not established. So the allegation he was present means the pattern is consistent, not inconsistent. That is the case. Then another case is Mukesh Mukesh versus National Capital Territory, Delhi. In this case, what happened was there was a gang rape. There was a gang rape. One of the accused invoked the plea of alibi, but he said that I was not available at the scene of offense. I was enjoying some music performance along with my family, he said. But that music performance, when the matter is referred to music performance authorities, they said that on that day we did not organize any music performance, no ticket or permission was issued to the person. And so the plea of alibi was not accepted and he was convicted. That is another thing. One more case, last case is Harichand versus State of Delhi. Harichand versus State of Delhi. In this case, there was a LLB student. He was writing exam. He was charged with murder case nearby village. But he said that no, 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 I did not commit murder. I was writing LLB exam. It was found that he was writing exam at 9 o'clock in the morning. His exam is for 3 hours, 9 to 12. The next exam would be after 2 days. After 12, after exam, there are the 2 days time is there. The village is very near to the village is very near. There is no any impossibility. There is a probability is there. There is a highly improbability is not there. It is improbable. So this is and he was convicted. Probability is not there. It is improbable. So it is not impossible. He can go within that time and reach this nearby village and this. So next topic for discussion is see here for alibi witness also reasonable distance also is to be maintained. Munshi Prasad versus State of Bihar. In this case, what happened was the deceased was the deceased was deceased was shot dead, but the plea of alibi was in court. No, I was not at the scene of offense. I was 500 feet distance. I was the 500 feet distance is not a distance. When a person wants to say that he was elsewhere, there must be reasonable distance. Reasonable distance also is material. So he cannot, he must be very long distance and there must be impossibility to reach. So distance between place of offense and place of accused climbing to stay is to be taken into consideration in this case. Now second point is non-access of husband. Non-access of husband. Non-access because illegitimacy of child. Suppose the woman tells that he is a legitimate child, he is your son. He claims against husband. But husband tells that no, I am not, I am away from my wife. There is no any cohabitation between me and my wife. Nearly 1 year elapsed. He can claim. So wife claims legitimacy of the child. Husband says no. But the words of husband inconsistent. The inconsistency of husband's words is relevant in this particular case, and the court can declare that the child is illegitimate, that is the child is not a legitimate child. So this is the position. So like this, according to section 112, according to section 112 of Indian Evidence Act or according to section 116 of the Bharatiya Saksha Adhiniyam. Both are same. Contents are same, section number different. If there is no cohabitation between husband and wife, if the gap is 280, if the pregnancy, the woman conceives child within 280 days, if a woman cohabits with husband and conceives child within 280 days, 280 days, that is 9 months 10 days, that child is deemed to be legitimate child. Otherwise, that if she conceives beyond 280 days, that child is deemed to be illegitimate child according to section 112, 112 of Indian Evidence Act and section 116 of Bharatiya Saksha Adhiniyam. But here there are some other grounds when the husband can establish inconsistency, stating that I am infertile. I am the man, if infertility of man also becomes an inconsistency. So, the husband, man and woman got married, but no issues for some time. But husband knows that he is infertile, but he doesn't disclose it to wife. Sometimes if any man knows that he is infertile, he silently marries a woman, he doesn't reveal the fact. Suppose after some time the woman gets pregnancy, he gets doubt. When I am not, when I am infertile, I cannot give birth to a child. How she got pregnant? He may challenge it, and he may be tested, or the child DNA test may be killed. Then if DNA, as per DNA, if a husband is not the real father, the inconsistency can be established, and illegitimacy of the child also can be established. That is another thing. This point I am adding extra, but only this 280 days cohabitation only it is given in this point. Third one is survival of the alleged deceased. Survival. Suppose A, it is said that A is charged with murder of B. A is charged. In so many movies also this takes place. But the person whom the court believes that particular B is dead returns. In so many movies it was seen. So in one movie, wife presumes that husband died in accident, got remarried to another person. When she started living with the second husband, the first husband comes. First husband returns. Similarly, in Talson case, Talson's husband, Talson and Mrs. Talson got married. The IPC Minsria case. What happened? Husband, Talson, Mrs. Talson's husband, Mr. Talson, bound for voyage. The ship was drowned in sea. All that were sailing in the ship were presumed to be dead. And she waited after 7 years. Even after she waited after 7 years, a person whose whereabouts are unknown for a period of 7 years is deemed to be dead. Having confirmed that her husband is no more, she got married to another. After starting her life with the second husband, the first husband returned. So that is why this is another thing. So here, that is another case. Now here, the Talson has other grounds. But in particular case, some movies, A is charged with murder of B, but before the end of the trial, the person whom all believed to be dead came out as alive. Then the case will be dismissed. If he would not return, the accused would have been awarded punishment, life imprisonment, death sentence, or anything. So then next point is commission of crime by third person. It is said that A committed murder of B, but B proves that no, I did not commit B, I committed murder of B, some C committed murder. So if it is proved that C committed murder, A's statement will be inconsistent with the allegation. So the allegation is inconsistent. Then he will be relieved. That is the third point. Fifth point is self-infliction of harm. Self-infliction of harm alleged to have been committed. Suppose here a man is found dead. The allegation is his rival so and so must have committed that murder. So I know after medical reports and everything, it is proved that that person is not killed or murdered. He himself committed suicide as per post-mortem report, expert opinion, everything. It is proved that. Then once allegation is murder, but actual thing is suicide. Murder and suicide, suicide is inconsistent with the murder. On the ground of inconsistency, the person who is charged with murder will be allowed to invoke the plea of inconsistency under section 11 of the act. But these five are available in almost all textbooks. But one more point, that is non-execution of document, is added, is shown in by latest in one article recently I have gone through, that is non-execution of document. So here A purchased a land from B. So whatever paid, whatever encumbrances are there between A and B is not known. But A demands possession of land, but B does not give. Then A filed a case against B. So the allegation is A purchased the land from B, but B did not give possession of the land. That is the issue. A purchased is the true relevant fact, B sold is the true, but the thing is, fact in issue is there, he is not giving possession. Then A said that the words of A not giving possession is inconsistent in this particular transaction, because the sale deed is not executed. Where after sale deed is executed, then only A has to fulfill some more formalities. Then only the sale agreement will be executed. Where otherwise, suppose full money is not paid or not, or any other terms and conditions are fulfilled or not. After fulfillment of all the terms and conditions only, the seller or vendor will get the land registered in his name, then he will give the possession. But otherwise no. So the claim of seller and claim of buyer is inconsistent in this particular case. So this is sixth point. So these are over. Then last section 11 clause 2 or section Indian Evidence Act or section 9 clause 2 of Bharatiya Sakshya Adhiniyam relating to the highly probable and improbable facts. Facts probable or improbable. Probable means most likely to true or most likely to happen. And improbable means unlikely to happen, opposite to this. So here section 11.2 or Indian Evidence Act or 9.2 section 9.2 of Bharatiya Sakshya Adhiniyam, the facts themselves, either the facts itself or the facts themselves are in connection with other facts or connection other facts makes existence means highly probable or non-existence or improbable. Any fact in relevant or fact in issue or relevant fact highly probable or improbable. So either a fact by itself or facts by themselves or in association with another make either existence or non-existence of the fact in issue or relevant facts, relevant fact. So there is a relevant fact is there, that if a relevant fact is in question, that is fact in issue is there. This fact in issue can be answered though not directly by some other facts which by themselves establish existence or non-existence of highly probability or improbability or highly probability or improbability. This is the position. So in this for this one example is there. A is charged with some crime. A committed some crime. It may be any crime, house breaking or theft or whatever it may be. So here A is not A, B, C, D. One of them committed the crime. The statement is relevant. whether A committed or not is investigated, B committed or not is investigated, C committed or not is investigated. If the circumstances so prevail that these four associate themselves, the crime must have been committed by one of them, A or B or C. Each and every statement can be found relevant to establish the probability, highly probability or improbability with reference to fact in issue or relevant fact. So that is the point. So here, if evidence can be adduced of every fact which by itself or in connection with other facts makes the existence or non-existence of fact in issue or relevant fact is highly probable or improbable. So here in illustration 2, A or B or C or D might have committed the crime. These statements, all statements are relevant. Or A or B or C or D, none of them have committed. So it is highly probable that A has not committed the murder. So here, the murder might have been committed by, is not committed by B or C or D. So it is improbable. It is improbable that it is improbable to say that A has not committed, means A committed the murder. Like that, it is improbable. That is, existence or non-existence will come into this. In this connection, there are two cases are there. Santa Singh versus State of Punjab. Here the deceased shot dead by one person dead by A accused shot at B died at a distance of 25 feet. But eyewitness said that the medical report eyewitness said that he from 25 feet distance A shoot at B died. But the medical report say that no, it is only less than 1 yard. So 25 feet is equal to 8.33 yards. 25 feet is equal to 8.33 yards. But eyewitness said that A shot at B at a distance of 25 foot. But the medical evidence proved that shows that the distance is only less than 1 yard. So whatever is said by eyewitness, whatever is said by witness is not consistent with is not correct. It is improbable, and the plea was not, the evidence was not accepted on the ground of improbability. There is one more point is the expert opinion rendered the testimony improbable. It is not, as per expert opinion, medical opinion, the witness is telling 25 feet distance, but as per reality is only just a matter of 2 feet, 2 feet only, like this. Here 25 feet is equal to 8.33 yards. So it is must be 2-3 feet only. Now coming to the and there is one more similar case on this point. State of Madhya Pradesh versus Surban. In this case, what happened that B died. A stabbed B. A hit B once from backside one time. But in medical report said that the deceased, they found on deceased body 3 incised wounds. 3 inside wounds, consequently he died. Suppose in one movie, Pokri movie, one person points a trigger, but another killed him. Because there is some politician addressing the gathering. There are so many murder attempts are there. Different rivals, different enemies try to keep their people at different places. But here 3 persons, suppose 3 attacks are made at a time. Whatever only one hit is not correct. It cannot be. It becomes improbable. It is not probable, highly probable, but it becomes improbable, and the claim cannot be the person cannot be convicted. These are the various issues relating to Section 11 of Indian Evidence Act or Section 9 of Bharatiya Saksha Adhiniyam, dear friend. Dear friends, you have some doubt about civil judge junior exam class, law exam class means all the lectures are common for student in private college, university college or prestigious national law schools. My classes will be sufficient, including the judicial service examination. After giving title of judicial service examination, I have elaborated the subject, but suppose for LLB I am going in deep. I improved the standard of the lecture because so that it will be useful right from LLB student to the candidates appearing for civil judicial service and national law schools also. With that I am telling. So far I have uploaded nearly 250 lectures. After title of this civil judges might be some 10 classes I might have given. But this generally, if I teach this evidence to LLB students, maximum 10 to 15 classes, so I completed CPC, CRPC evidence like that. But for civil judges exam, I will improve the standard. I will increase the volume of term of the lecture, and I give some 15 to 25 classes. Suppose if the classes are exclusively for LLB student, by this time the syllabus would have been completed for LLB. But I am taking so many classes for this evidence exam because evidence is most important subject. Evidence, CPC, CRPC. By the time I complete this evidence, I may wait till July for this. Even though I have not covered, I have given good number of lectures in IPC. I have given good number of lectures in CRPC. If you watch all my lectures, it is not so easy. There are nearly 150 lectures. But if you discard 50 to 60 lectures are in Telugu media, but non-Telugu candidates, the students from different parts of the country other than Telugu students in states of Andhra Pradesh, in Telangana. If you watch these around 200 lecture, it will give you very good idea, very good knowledge. You will be able to face any examination very comfortably. You will be able to understand any book independently on your own. You will be able to, if you watch my video as and when notified, you watch it once by downloading it or sharing it, and the remaining lecture in 2 days or 3 days, if you can watch one lecture, so you will be able to acquire very good knowledge. You will be in a position to face any examination. You will be in a position to face any competitive examination. Once you have watched all my lectures during your student career, it will be very easy for you to face the competitive examination, civil judge junior examination, everything. I sincerely tell you to watch my each and every lecture. I promise you to do my best. You need not have any doubt. I will deliver wonderful wonderful information. I refer all the books, internet and everything. So I work so many hours to deliver lecture in 1 hour to 1.5 hours. So because in case LLB classes from 3-4 sections would have been completed in one class, so I go in very detail. Please make use of my service and share the same to your friends. I once again express my heartfelt gratitude to my student friends for your consistent affection and support in reaching my channels, in promoting my channel to 16,180. In a day or two, I see 16,200 will be completed. Thank you very much for your patient hearing. Thanks a lot.